Welcome to the Establishment Subcommittee meeting of the 14th of October 2022. We dealt with the agenda items for the Establishment Committee in the community call. So this is a short welcome and then we'll go straight into the recording discussion on insurance for the Law-Fi-DAO model. Thank you. I might start with a bit of a recap on last week and then a briefing for like the issues I think that are immediately obvious out of the NFT membership token in terms of what are the features or characteristics of what we're proposing that would make an insurer balk or would say what other mitigating measures are you implementing to manage your exposure to risk of loss or claims. So last week on the pay to rely model, we were just talking about actually what is it perceived to be? Is Law-Fi and the smart contract protocols that we hope to build, is that considered a facilitative, a separate platform, like a technology or a software that is provided to the, initially the legal industry and then eventually other professionals? So that if Bedazzle, as the law firm, and myself as the qualified lawyer employed, if we want to use Law-Fi-DAO protocol to release a pay-to-rely product, so that might be, the example was MKR is a financial product under the Australian Corporations Act. And that's the advice that I mint using the protocol. So it effectively mints as an NFT. There's also an engagement letter and costs agreement that we prepare templates for. There's one for New South Wales, there's one for Vic. It's a state and territory based regulated legal profession. So Bedazzle, we visit Law-Fi-DAO website to get the benefit of those templates and the protocol. Similar to the way that you would interact with Uniswap. You just connect your MetaMask wallet or whatever wallet you're using, and then you pick your trades. Uniswap Labs, the company, they provide the website front end, but and they service the protocol, but the protocol, they say, is separate and not something that's owned or that they're necessarily responsible for in terms of regulatory and tax obligations that might come from a person's interaction with the protocol. And that's that separateness that we're always trying to understand. Is the protocol actually separate from the service entity? And in this case, we're an unincorporated association. We've got a vote coming up to be registered as an incorporated association. But is that still enough to separate us from the protocol, which is intended to be separate, but there's no legal regime still that recognize distinct legal personality of an autonomous protocol? So that we will always have to manage that risk that the Law-Fi-DAO as an association may have to bear any risks or claims in relation to any person in the world's interaction with that protocol to produce pay-to-rely products, and a token exchange might be the one that buys that advice that MKR is not a financial product because they only want to be listing tokens that are not financial products. But, ASIC, the Australian regulator, could say, we don't agree with the Bedazzle pay-to-rely product. We're now going to fine you, token exchange, and token exchange would then, this is the confusing part, we don't know whether they would have only rights against Bedazzle as the law firm that produced the pay-to-rely advice, or Law-Fi-DAO, or both.
They can't see. You can't have disclaimers and make clarity between Bedazzled and Law-Fi-DAO about where the responsibility lies. So you're saying that's the unclear bit, isn't it?
We can do our best to try to make that clear. And obviously the position would be that the lawyer that's submitting the advice takes full responsibility for any claims to the extent it's wrong.
Yeah.
Where this really starts to get grey, though, is if we include the peer reviewer protocol as part of our overall suite, because that is where, through our platform, we're facilitating a process for lawyers 2, 3, and 4 to review the bedazzle advice. And then it's through our attribution model that says, well, lawyer 2 agreed. So does that mean that because there's only 2, that liability should be split 50-50 between both of them, or a different basis? And if lawyer 3 disagrees, that sort of mathematics is an initial proposal that we'd need to think about.
Okay, so your insurance issue comes up is because law-fi DAO may have some liabilities. Is that correct, Joni?
Yeah, I think if we do approve the insurance pool and a revenue distribution pool, law-fi DAO is a platform where there is money to fund claims. So if Bedazzle and lawyer 2, for example, don't have enough money to meet a claim, law-fi DAO will be whether or not there is a valid insurance claim against. I suspect law-fi DAO could be in a position to still have to defend whether it is liable or not to have to fulfill an insurance claim. And so do we front end it by having this self-insurance pool and a clear claims process as to when law-fi DAO clearly takes responsibility for paying out claims? And that might be, for example, where it gets to, I don't know, more than 5 peer reviewers, and where there's liability over $2 million each person, then there's a further $2 million cap that can be claimed against the law-fi DAO insurance pool because of the one-to-many model that law-fi DAO is introducing, which escalates the level of loss or dollar worth of claims that could go against the lawyers. That's what law-fi DAO is introducing.
So what do you think? So when you talk about an insurance pool, what do you mean? What are you talking about?
A funded pool, just it's probably going to be in stable coins, US dollar pegged stable coins, where part of the pay to rely revenue, it's split, some to the contributor, some to the peer review pool, some to the insurance pool, and some to the revenue distribution. So it will slowly accumulate, and it's with those funds that are used to pay out any claims against law-fi DAO.
You're talking about millions of dollars potential claims. So you're talking about a very large pool being built up. And that's, I just, is that what you want to do? Wouldn't you?
Well, maybe not. So this is what the members will be voting on this afternoon. And the way this might ordinarily come about in any other DAO is that they say, we organically realize we need some sort of self-insurance scheme. Most DAOs use or may rely on what's in their treasury wallet. So in a sense, there's no segregation between the funds they intend to use to pay out insurance claims. What law-fi DAO does by, proposing it as a separate thing is to have some segregation of assets on account of paying future insurance claims. So it could be insurance claims around the pay to rely model, as well as how the officers of the association are running themselves. There could be any number of claims. I'm just giving you the ones in relation to the pay to rely model. But this could be a sub DAO that it becomes too much of a distraction against the core pay to rely protocol that, Rick, if you do stand up a separate insurance, thing for DAOs, then it's not necessary so much to have it as part of our suite, because finally there's something in the market that can service DAOs from this perspective.
Yeah, that's what I want to do. So sorry, I just because so what I'm not sure yet is the underlying what the underlying perils. I need more information on the underlying perils, and the way I think there are structures within DAOs. Well, what the underlying perils are, which category of insurance they sit in, and importantly, I think there's a lot of the constructs in DAO I think can be used to mitigate the risks. I think at the heart, the insurance industry is running away from anything like this at the moment, and I think that that's because they're risk averse and they don't know the risk. I actually think that there's some constant. I'll give an example. I've heard there's a lot of we did a survey of the blockchain members, and they said they're having trouble getting D&O insurance, and
yeah, that's a typical one.
and I think I think we all would agree that there's some elements of what we're doing with DAOs is actually we're breaking down the hierarchy between D&O. We're sort of not getting rid of. We're democratizing the concept of directors and officers. So that to that extent, that's unlike philosophy, there will mitigate the risk. So if you present this properly to the insurance ins, so I believe that makes it. So I want to set up a kind of like a self-insurance pool, really, of a number of entities that that understand the risk. So rather than saying, oh, it's digital, it's Web3, so it's scary, we don't know it. It's saying, oh, okay, here are the standards that you have to have and if you meet these underwriting standards, we will write you. So that's what I'm in throes of doing over the next few weeks.
Forgive me, Rick, I've also forgotten. So Andrew, did you want to give a summary of the DAS as well?
Yeah, I think it's probably worthwhile. I think, Rick, there's a couple of points here, and before I talk about the DAS, I'll talk to you about the organisational engineering of the DAO itself. Because, and I should send you our School of Thoughts paper to give you a heads up on that, which I will. But basically, what we're looking at as Multilateral Group is we're looking at the fact that DAOs are pretty nascent, and the type of DAO that has been established presently and is the dominant style goes down a particular type of path in its attributes, if you like. But going forward, and if you take a bigger view and you look at, well, what does the design of an organisation look like, and how does it interact with established regulators and jurisdictions and all those sorts of things, there is room there to take a broader view on how these things can be established going forward. And the model that we're looking to build ourselves for use in this space, for the want of a better term, I'll call a hybrid, but it's a model we call Exemplar DAO. And what it does is it takes, it separates out the tradition. It's based on, think about a next generation cooperative type principle. So it's based on cooperative principles with member classifications that are designed upfront, that are the bylaws that sit with smart contracts for obligations, participation, all those sorts of things. But it has also, as a component of this, and it's based on a program that Joni would be familiar with, which is Koala model rules, which were developed a couple of years ago. So we've referenced that and built that out in the way we model it. And we're looking at functional and regulatory equivalence in the design and then the strategic implementation of this.
Equivalent to what?
Two parts. So one is, if we look at regulatory equivalence, look at the basis of existing laws. So we're basing it on cooperative law. Australian national cooperative law is the place that we would reference this. The intent is that because this legislation doesn't exist anywhere, we're looking to mitigate the risk of a very uncertain world and bring some sort of control around that says, well, when legislation or interpretation does change in the future, we've done all the things like look after consumer risk, we've accepted where responsibility lies, etc., etc. So we build all that stuff in. And at the heart of it, we have what's called an administrator, which actually separates out and is probably the bucket for where I would see a balance of risk sitting here, where depending on the model classes, there is actually an accountability scope for a central piece, and this could be an individual or an association or an entity of some form that takes on the risk and manages the communications with that particular member group. So basically what you're doing is you're ring-fencing governance, quality management systems and risk as functions that can't really be fully decentralised. Lots of other things can be, but those things need some sort of central structure. So that's where the hybrid piece fits.
Okay, so can I that's really interesting, because all the discussions I've had, and I've had a few discussions, a few DAOs, it's that issue. I agree with you. It's just a next gen cooperative. That's how I've been thinking about it. The whole thing, and there has been some naivety around the ability to disseminate a lot of the procedural stuff. And so what you're saying is it's really consistent with where I've got to and how this thing should be done. So I'm really pleased to hear that. So what you're saying is, because there is some centralized. So I just want to say, so you're talking about centralizing some functions, and that will have associated risks which need to be insured. Is that correct?
Yes. Yes.
I can say first, whether you centralize or don't centralize functions, there are risks that need to be insured. The centralizing, the decentralized activities that are not centralized you still might need to look into potential claims somehow coming up there. Maybe they can be mitigated, maybe not. I'm not sure. With the if there is an administrative function that is to some extent centralized, that's where there becomes we need to unpack what the underlying perils are, work out what mitigation can be put in place, and then build the insurance around that, which is what I intend to do over the next few weeks. So
Can I give you an example, Rick? Because so with the UKI DAO, the CFTC, Commodities Futures Trading Commission in the US, made a complaint against UKI DAO, and they defined the DAO as all of the members that had voted. Now, CFTC doesn't have the identity of the majority of them. Therefore, they have made a complaint against defenseless persons, and there's amicus brief that have been filed, so literally friends of the matter, to defend those people that voted. But because the way that the CFTC complaint was filed, those members couldn't even cast a vote to allocate funds in the Treasury to fund their defence. So that's where there may be a spreading of risk, or like democratization of directors and officers' duties by getting more people to vote. But then this was a situation where there was no insurance pool to allow them to draw on to defend themselves. And if that CFTC complaint becomes a judgment because there's no defence, that creates an awful precedent for DAOs, and essentially that no matter if they're decentralized, regardless of the level of decentralization, the CFTC still expected that because of the nature of the protocol, which was basically a margin leverage trading pool, the DAO members should have voted from the get-go to outsource or to have somebody register the DAO as a trading venue with the CFTC. And so that's where, like, to date, people have been thinking, oh, if we're sufficiently globally decentralized, do we register with all of the applicable bodies, or one of them, or none of them? And now it's only by this enforcement action that we see, well, the US definitely expects, even if it's globally decentralized, that it will be registered in the US at least, which is not something we've really known until now.
Okay. Yeah, look, I hear. If I'd like to know what. That's why I say caution. Even if you don't decentralize, you know that there is the potential for claims. The nature of the claim and what the loss causing claim was, I'd be interested to know.
Well, there was a fault in the protocol, a vulnerability, and so all of the people that interacted, I think about $50 million worth was siphoned out of the protocol, and that was one of the things that got UkiDAO on the radar of the CFTC, because they hadn't done enough security auditing or checking of the protocol before it was deployed, and they would have if they had have been registered and been held to like a higher standard, is what the CFTC is saying.
So is your reflection, just forget about the multi-registration, just think about registration for the minute. So is your approach, the approach generally is to, it seems to me to be to find out what registrations are needed for DAOs to operate in the world. That seems...
Well, yes, but the second part to that is what Andrew mentioned of regulatory equivalence. Yes. So if you take the position that you can't register with any jurisdiction, you still try to conduct the DAO as if you're equivalent to the outcomes that the regulation is trying to achieve.
Okay, so what I am interested in doing is working out the set of requirements, the recommendations to make to DAOs which want to get the which means that they can mitigate their risk to the extent that they can be insured. So that may regulatory equivalence is good, but you need to unpack that a bit, because
well, the regulators are not accepting regulatory equivalence.
The piece, Rick, the second part of the equivalence is the functional equivalence. So what I take out of the UkiDAO piece, and thanks for unpacking that a little bit further there, Joni, is the lessons learned in what we talked a little bit last week about the digital design of the organisation in the first place, right? Which is the other thing that we are looking at. That is the Wayfinder process that Multilateral Group have got in the market at the moment. And basically what that's saying is, well, let's look at the organisation. Generally, what we've found, and back to the DAO piece for a moment, most people are very narrow in their perspectives of what they're looking to achieve. They tend to be focused very much on where their specialty is, which is what you would expect, and a lot of it is very technically led. But there are so many other parts of building and establishing an organisation, particularly a next generation digital native organisation, that people simply miss. We've got a cheat sheet with hundreds of different points that break up all these particular elements. So looking at that UkiDAO piece, they if they'd have designed their organisation properly in the first place, they would have known that they had to establish certain standards to mitigate the risk. And in the way that they built their operational model, and this comes to the functional equivalence, Rick, they would be able to tick box off and say, well, we've done best endeavours. We know the law, there isn't a law here at the present time. We know it can't do a registration, but we know we have to do this, this, this and this to mitigate the risk of loss in that underlying perils piece. And so it's really saying, well, we're taking what is a nascent organisational structure, but applying very established rules to how that builds out. And that's the stuff that people that are in the marketplace, like insurers, actually understand. And then we use the technology piece to make what is possible. And clearly there's a lot of things that in a digital world we can do that you couldn't do in an analog world. So.
Look, your thinking is absolutely aligned with how I've been thinking about this thing. That the sort of establishing, giving guidance, support to DAOs, so of what they need to do to become insurable. That's exactly what I'm intending to develop. But the other side of that coin will mean that there will be DAOs will have the choice not to meet those standards, and therefore not for any entity that I or we set up to not provide insurance. I mean, it's a free world.
Well, at least they at that point know what they don't know,
yeah.
and that's the point. This is saying, well, there is so much unknown unknowns. We can actually bring forward a lot of those known unknowns, and then people can take a choice what they want to do, what they want to mitigate against, or not.
Yeah. So because we're in a new world, my intention is to work with a few organisations, few entities which need insurance, and to work out what works, to insure them, but keep the exposure small, and over the next 6 months work out what works. And then I've been told that there may be like significant funding available to set up a significant pool. Because Jody, I have to say, I don't know anything about the finances of Law-Fi DAO and stuff, but setting up a pool to cover risks, you get premiums are a lot less than claims. I mean, in the individual, in the aggregate, they should be more, but that's you're opening up a big can of worms for yourself. I don't.
Yeah, no, I agree. So it's a huge undertaking and a specialist undertaking on its own. Yeah. But the best Web3 lawyers are recommending that DAOs try to do some sort of segregation of assets, at least, to fund claims. So at that very base, that might be what Law-Fi DAO does, and not necessarily be its own insurance scheme. But we have to be thinking about what we can do to protect the members and the people that engage with the protocol.
Okay, so sorry.
It's a bigger than Ben-Hur stream on its own, absolutely, and that's why we need experts.
Well,
helping us.
I can't remember the story, but maybe I can be the insurance Ben-Hur here. But so you said you have a vote today. I'm going to make. I've got calls from 9. I've got a pretty. What I would like to suggest is that we go into. I don't know exactly what's the vote today. I want to help. I really want to set this up. I'm pretty excited about what I hear and what I see is what can be done here. And I want to set up the insurance world. Really, it makes the legal world look totally innovative and radical. I mean, they're really it's a really fuddy-duddy world. It's a very risk-averse world. Particularly in Australia. You're going to find it difficult I mean, I can tell you who to talk to in Australia. You'd be frustrating. Bermuda's pretty impressive, but it is a lead. I mean, because of guys like Steve, it really is a leading jurisdiction in the world, which is why I want to set up the company in Bermuda. And then there's a lot of protocols. So I want to look after all the insurance stuff. So what's your immediate insurance? And what I want to do is have discussions, direct discussions with DAOs about what their insurance needs are, and then design contracts to meet those insurance needs.
Well, the big one, not in relation, I'll tackle a few of your questions, but the big one that doesn't apply to LawFi DAO right now is, from an Australian law perspective, whether the issue of their tokens has been a financial product as a representation of an interest in a managed investment scheme for which the DAO, the founders, or you call them the officers or shadow or de facto directors, haven't obtained a financial services license or a registration or an approved prospectus with ASIC before they offered that financial product to the public, including retail investors. That attaches fines and potential jail time, for which whoever is brought into that claim, should ASIC ever make one, they would be in need of the D&O type insurance to fund their legal costs. If the Treasury didn't have any further assets that the members would approve to apply for the founders or the officers to defend themselves. That's probably the big one.
Yep. That's D&O. It's D&O, and the suite of insurances, but I'm calling it professional liabilities, but I'm calling it D&O and cyber are the two ones that I've been told that I've become to realise are in need. So yeah, absolutely. That's the one I'm going to start unpacking from Monday.
And the other one, but I don't know that Australian founders have necessarily been involved, is these hundreds of millions of dollars of hacks or attacks on bridges. So you had the $600 million one with Ronan Bridge. There's been a $150 million one recently, but there's been 5 or 6 of them now. And so I think Ronan, they actually raised capital, and that one of their existing lead investors led the other round, and the round was basically to pay back all of the money that had been lost. So that's how they had adopted their own self-insurance, so to speak. And so the shareholders raised money to fund the claims of loss from all the people that lost money in the bridge attack.
Yes, I went. I'd originally designed a coin cover type, a coin insurance against loss of coin or against loss of seed phrases and stuff. I moved away from that, and I will go back there. But the intent, the pressing need, I've been told at the moment, is for the insurances that are needed so business can get up and running, which is like D&O and cyber. You have to have D&O before you can go into business. So this is I've been told this is a pressing need. There is also, so there were a number of different arms of insurers, including the hacking. There was there are other insurances that I was going to use for DAOs. I don't know if you. Anyway, but the D&O is the one I'm focused. The things to get so companies can get up and running is.
Well, I think maybe just a slight variation on that. It's professional indemnity insurance that's needed for anyone that wants to hold a financial services license. That's the tick the box exercise. Yes. And the key thing I think that's holding insurers back from PI is that cyber risk of, if the exchange is managing its own custody of all of the clients' tokens and they lose a seed phrase or they're exploited, that some of these exchanges have got billions of dollars of assets under management. So that they see as uninsurable, or the premiums are price gouging.
And to some extent, given the status of the protocols now, I have to agree with that a little bit, because what I was going to do was establish the mitigation processes I was going to use was you have to have offline storage, cold wallet storage of your coin and stuff. That was necessary to get insurance, but I was at the beginning of that, and I still hold that position because I think we're about my estimate, we're about a few years away from having secure online protocols for storage. So I'm here to help design your insurance needs. You've got a vote or something today.
Yeah.
Relationship with that I mentioned through Blockchain Australia. That's in front of me. I have not met them yet, so I think that whatever I'm doing through them, I will want to broaden out. I will want to broaden out so that it can also cover LawFi DAO and other DAOs somehow. I will have to work out some way of setting up an umbrella organization above the DAOs so that they can be, but that'll be a useful process in itself. But that, once again, you're much more, you know what you're talking about in this area and who's a who. So we'll get that. So what do I need? What can I give you to help you today for your meeting?
Well, I think my first observation is that it sounds like you're going to do a DAO co-op for insurance.
Yeah. I mean, I'm setting up. I'm doing a lot of. I'm a really big fan of co-ops and mutuals, and I mean, when you unpack the DAO, as Andrew says, it's a next gen mutual, which I really like the concept, you know, and I do think there's some naivety, but which Andrew kind of addressed a little bit, which is starting to be addressed around dispersed decision making, which I am a fan of. But yeah, so I want to set up an insurance offering which is consistent with the principles, the principles we're all trying to build our DAOs on, the Web3 principles. Absolutely.
Yeah, well, I think in the presentation today, you know, hopefully you can watch the recording afterwards, and Greg, yourself as well, in going through, you know, the options for what protocols we should include in the suite. I think that this discussion will be fed back into these are the things we need to consider with including the insurance protocol. And but with the proposed resolution of subject to Consumer Affairs Victoria being willing to register the incorporation, you know, based on what the members, you know, prefer to be included in the protocol suite, and they may say they want to include insurance, then the members give their approval. So what I expect with that sort of conditional resolution, Consumer Affairs Victoria is not going to be happy, because you're supposed to have quite a clear, you know, tick, yes, we want to incorporate. But I think Consumer Affairs Victoria will say, we need more information. If you want to include insurance, we need a design proposal, exactly how it's going to work, at least version 1. So when we get that, in preparing for getting that request back, we could prepare some of those materials with you if you've got the time.
Oh, absolutely. I mean, I do want to provide. Yeah, I'm just I think for Greg and Andrew, I'm an actuary, whose background is in insurance, and also I'm an Aboriginal actuary, and so a lot of the principles, there's a lot of cultural principles that are being espoused in DAO, which are consistent with a lot of the ways things are done in non-Western and Aboriginal societies, which I think becomes relevant here. I mean, I personally am trying to. I would like to think that we're all, where possible, as we grow up, mature as a nation, we'll be bringing Aboriginal ways of doing things into the way we do business in Australia. So, and I see this as an example. What we're talking about with DAOs and how I will be working on this, it'll be consistent with sort of bringing in where appropriate, aspects of Aboriginal approach to business and commerce and life. You know? That's personally very important for me, and until Australia starts adopting Aboriginal ways, it'll remain a colony. So.
And however we can bring you in, you know, your network, the better, as far as I'm concerned. So thank you for your kind offer, Rick.
Yeah, I'm excited by the opportunities here, and I want to run this. So if you want to if you're having a vote on should we set up insurance protocols, I mean, yeah, no harm in saying yes to that, and then we can work out if I can work with you on the details after that. Yeah, I'd be keen to do that. You know.
Great,
yeah.
Good. All right. Well, so Greg or Andrew, any further responses or matters to raise, insurance or otherwise?
No, nothing from me. Rick, I'll dig out your details. Are they the same as they always have been, or have you got different details?
Oh no, I'll give you my number if you like.
Yeah.
Number.
Maybe
04.
offline.
Do it offline. I might already have it. I'll send you a text, and if you get it, it's the same one, and you can send it back and tell me what email you want me to use. Yeah.
Okay. You can. Yeah, that's fine. Okay.
Yeah. All right. If you don't hear from me, you know I haven't got it, and you need to reach out to Joni to get it. Yeah. All right.
I should have an offline discussion at some stage, Joni. We've got each other's numbers, I think.
Yeah, I'll give you a call after this. No worries.
I've got a 9 o'clock call I have to go to, so.
No worries. Thank you so much for joining today, Rick. Speak to you soon.
Okay, bye.
Greg, anything?
I just want to check, are the resolutions on the website for today?
I don't think they're on the website. They were, I think, just in private correspondence to members, but happy to put it up on the website.
Well, could you email me a copy just so I could see what's up for discussion?
For voting, yeah, sure. I'll do that just after we get off this call, Greg. I've just lost my Zoom window, so now I don't know how to get back to you. There we are. So no worries. All right. So we're happy for this morning?
Yep.
Good. All right. Well, then treat the 9:15 as cancelled, and I will see some of you for the 2 p.m. UK Law Commission. Otherwise, Andrew, you at 4 p.m. for the general meeting.
I will see you then.
Looking forward to it. Thanks, everyone.
See you.
Bye.